Well, first of all, thank you very much. It's really an honor for me to participate in this amazing course. I mean, I was immediately honored to participate when Professor Martinico sent me the invitation, and then I saw the program, and I was a little bit like, well, I don't know if you know, the spy that I'm trying to poke in this book on constitutional crowdsourcing. I need to acknowledge that you have very big names, and for sure it's going to be a very interesting and very interesting course. And I really encourage not only PhD students but also the students in University Autonoma to participate and to follow some of the ponencies and courses that you're gonna have. Well, the book. So again, I'm very honored to be here. It's really a pleasure to see you, Giuseppe, but also Giacomo and other friends. The book that we were talking about is this one. I think Eduardo will be very happy about the publicity. So. And this is as you mentioned, the last book that I wrote. Now I prepare a PowerPoint because I need to acknowledge that I'm a very unstructured person. So always to have some kind of a structure is very, I think it's very helpful. So I also wanted to pay tribute to this course that Giuseppe and Professor Monti have arranged, because as I said, the topic it fits perfectly with what I did in the book, with the latest events in constitutional law. For example, yesterday we had the elections in the Chilean Constitutional Assembly that is going to redress or not. We will see. The constituent processing in Chile, right? I think you have Professor Verdugo that he's going to talk about this extensively in a couple of days. So let me start to provoke you, because as the book at the end of the day is also a sort of provocation. So and I think that with provoking people and provoking myself, it's a good way to push towards new ideas and try to reconfigure ancient and very established thoughts. So let me make this first reference to Professor Martinico, that he uses as a motto, constitucionalista loco, which means among our friends. Sorry, I know maybe this is what we did was private, but I don't know. But I needed to play with.
No worries, okay. No worries. Go ahead.
So it means that the crazy constitutionalist in Spanish. But you know, and I'm using the DemoCrazy, which is also another crazy guy. That this is something that I was labeled around 15 years ago in a conference of political science in Texas A&M. So all the participants there were telling me that I was a DemoCrazy. So I think it fits about two crazy people talking about two different ways to address and to talk about this complete issue of constitutional crowdsourcing, which combines constitutionalism and crowdsourcing as a way to provide legitimacy, or we will talk later about it in this presentation. So the first provocative sentence is that there is no legitimacy other than democratic one. I said this sentence not in this book, but in other books, in other chapters, and the people reacted very eagerly. I lost a lot of friends because of this, but I still think that at the end of the day, this is what I think, and definitely I wanted to use it in order to, as I said, engage a kind of provocative thought in the participants. And then the other one is this is not mine, to be fair. I don't remember, it was in one of these conferences that we have worldwide, that it says someone told me sovereign is the one that can escape constitutional empire. And I was thinking about this sentence because for me it also represents what the concept of sovereignty is, an evolution, of course, of Carl Schmitt and other different definitions of sovereignty. But also it shows you how is the empire, the domain of the constitution and constitutionalism, and the ones who are making this interpretation of the constitution of we are exercising the derivate constituent power. So the research question that I addressed in the book was how the network society may open new ways to democratize constitution and constitutionalism. thinking about principles, values. When we're talking about constitutionalism, I for the sake of the conversation here, I prefer to simply stick on the very general understanding of the concept that Rosenfeld and other professors are using, saying that, well, constitutionalism implies it can be constitution without constitutionalism, and maybe the other way around, but constitutionalism means the respect of some basic principles such as division of powers, checking and balance, charter of fundamental rights, and limitation of the prerogatives of government, let's say, and also some values that are related with this concept, idealization and mystification of what constitutionalism is. So that was the main question that I addressed when I was starting with the book. I would say, well, maybe the network society, all this internet, all this digital era, all these new events that we are facing can be understood as an opportunity to implement tools, to implement possibilities in order to engage population in the constitutional realm. I mean, I know there are a lot of skepticism. There are a lot of problems with. There are many conditions, warranties that we can talk, and we will talk about probably today, and you will talk about this along the whole course that Professor Monti and Professor Martinique are presenting. However, as I said, I think I'm optimistic in the sense that this open a branch possibility in a moment where, as we see, at least in the vast majority of the world, we are in a, even though we have problems worldwide, I think that we will acknowledge that we are in the best democratic period ever. Maybe we have them at least in the 50 or 60 years. And with the people, with a less rate of illiteracy also worldwide, meaning that if we have the tools, then we have no excuse to provide the possibility to the people to express themselves about questions that which are, at the end of the day, essentially political and not legal, because as we will again later talk about, constitutionalism and constitution, as we all we know, is not a strict legal norm, but also a political one, and therefore the ones who are interpreting the constitution should be democratically in constitutional democracies elected. So the table of contents that I used in the book, and I will follow today, is basically I started with an introduction to constitutional crowdsourcing. What means constitutional crowdsourcing? I will explain you, as I said later on. I also analyzed from a cognitive linguistics and what crowdsourcing is, what crowd meant, and what constitution is and meant, ancient constitutionalism, modern constitutionalism, and how this has been evolving, and the relation. I'm focused, of course, in the relation and the role that the crowd, the people, and other terms that I'm using in the book played in constitutional and constitutionalism. Then I focus more strictly in the crowd in democratic constitutionalism, so-called democratic the constitutionalism, because for me this is an antinomy. Then I follow up by the network society and the democratic constitutionalism. I mean, how this network society, basically Fondic and Manuel Castells, who is a professor from my university, Universitat Autònoma de Barcelona, and then he went to the United States, how they already predicted 30 years ago how this network society was evolving till nowadays, and why I'm saying that this network society at the end of the day can be also a good opportunity to improve and to engage these tools for allowing people to participate in democracy. And so basically in decision making, I'm of course interested in deliberation and participation, but I'm more focused on decision making, because decision making, and as we know, especially I know Giuseppe Martinico and Giacomo Dell'Adone know, because they have work and they have been studying about decision, can be related with the theory of decisionismus. The one who takes the decision is the one who is the sovereign. So if we are, at least in the title, as people, the ones that in the Constitution says that we are the sovereigns, we need to be part of the decision. Then I work out with this crowdsourcing and constitutional making, and which it has been, I need to acknowledge that this is a little bit, I had the luck to participate in the Icelandic constitutional failed. People say failed, but I don't think it was a failure at the end of the day. We can talk about this later on. But the Icelandic constitutional experience, and then it ends with the Icelandic constitutional experience. It starts with a different stage, how progressively the people was more and more involved in constitutional making. And finally, I'm working, I think this is something new. This is jumping out from the theory and from the case scenarios that we are observing to something which is more experimental, which is how can we manage to provide at least a way to the people to participate in constitutional interpretation and constitutional control. I'm more focused, to be fair, on constitutional interpretation. Constitutional control is less developed in the book. I read a long time ago some statements about the need to maybe involve the people in this kind of constitutional interpretations in Andrew Arato work, but he did not develop a theory to enable the participation of the people in constitutional interpretation. At the end of the day, to enable the people to participate in the derivate constituent power, right? So this is basically the table of contents of the book. Now, let me explain a little bit also very fast, which are some of the methodologies, because that I was using in the drafting of the book. I'm using a kind of a deconstructive from the postmodernist deconstructive theory, basically on Derrida, in order to analyze. But this is normally the methodology that I'm using in my works, because I'm a philosopher. And therefore, as a philosopher, being a philosopher and a legal scholar, it helps me to deconstruct concepts and to epistemologically analyze and then see how things are. I mean, Derrida had a lot of definitions of deconstruction and how the deconstructive theory must be applied. He, in one of his basic books, he says that you cannot use deconstruction to then reconstruct, but he is doing so. But I don't know whether I need to be so accurate in terms of respecting what the definition of the theory that Jacques Derrida provided. Then I'm always, as I said before, trying to escape of a sort of nihilism and saying that, well, you know, but in this book, I think nihilism was not really an option, not because I am per se someone trying to find a solution and to avoid this nihilism. But again, because I understand that we need to escape these interpretations that say that the dehumanization of human beings, of Homo sapiens, with all this kind of new Homo digitalis and digitalization, it's finally taking our nature, and therefore it does not help in order to provide tools, etc., etc. And the people is easy to be controlled nowadays. That we're changing our ways of expression, etc., etc. But as I said, all this, let's say, momentum that the digitalization and the network society is providing, I understand it as a possibility to improve the participation and decision making of people in constitutional issues. So, and as I said, I am also presenting at the last chapters a very, let's say, a new alternative theory, which is, again, it's a very basic one so far, but which I think that the main idea of the theory was not to set up the way in which the people can participate in constitutional interpretation and control, but to open up the possibilities of a debate, which it should be, as I mentioned in the book, adapted to each of the constitutional systems and legal systems, because casuistry and all own particularities are conditioning how do we implement, or can we potentially implement this kind of theories and mechanisms. So the book is multidisciplinary and interdisciplinary. I'm touching upon political science, of course, constitutional law, anthropology, philosophy, political philosophy, history of philosophy, etc., etc. and with all these tools, I ended up producing this book. Let me first, because I think this is this shows that how the mob, how the crowd has been always has been always suspicious, has been always even in a pejorative sense, but also that there is always a possibility to think in another way, right? So I'm myself a Catholic, so for me these sentences, I listened when I was a child, and I also even asked my father and my mother, my mom, why the people wanted to free Barabbas and not, and to condemn Jesus Christ. And well, my father says, because the people, the people. Well, you can read in Luke, with the loud shouts, the sisters they demanded that he be crucified. And they is the crowd, the people. And then also in the Bible appears that the reason the crowd turned on Jesus was because the chief priest and the elders persuaded the crowd to ask Barabbas. Well, it doesn't, I mean, you can read both sentences, and at the end of the day, you will see that neither of the sentences is very, let's say, positive with the role of the crowd, because the second one that shows you that the crowd can be easily manipulated and try to be infantilized and patronized. So, but I think this even from a most spiritual and religious perspective shows you a pejorative starting point and consideration that the mass has. So the introduction of the book is a fake judgment. Is a judgment, but following what judgment is nowadays. In one side we have the Demos, which is represented by Pericles, and on the other side we have Aristos, which is represented by Thucydides. I need to be fair. I use it Thucydides because of some reasons. I had a lot of criticism because they said, well, why you don't use Plato? Well, because for me Plato is also Socrates, and therefore it was not clear whether to use it as the lawyer of Aristos, and because at the end of the day I think that Plato will win easily a procedure against Pericles. So I thought that Thucydides even is an historian and he was a member. It's maybe not too fair to say that he was in a very pro-aristocratic perspective. And I'm seeing in the books Giuseppe, and I know that we can talk about this, how this dichotomy, this antinomy, this to placing it one against the other can help positions of, for example, populism, that he's an expertise on this. But I'm trying to avoid this. It's simply a fake judgment in order to see how was the evolution of the understanding of the role of the people in constitutional matters. So I am starting from the first political classifications in Athens and with Plato, Aristotle, Polybius. Then I jump into the Roman ones like in Cicero and others until the Magna Carta. I'm following stating which are the position that democracy and the demos was always the last of the let's say political classifications, which was this politeia that then it was translated as constitution and constitutionis, right? Then I'm following and analyzing deeply the Enlightenment in France and in the founding fathers, the debate between this is something that then I go in deep in other chapters, the debate between the Federalist and the Anti-Federalist, the role of Jefferson, Madison, Jay, how Madison was considering the mob, that they need to be protected, etc., etc. In the first introduction, of course, it's simply a testimony. Then I jump into interwar constitutionalism, the very famous Weimar Constitution, and I'm saying in the name of Aristos that, well, Democrats, they were the ones that you helped the rise of Nazism, etc., etc. Then, of course, I also answered that was not really the case, because as we know, when we studied the interwar events in Germany, we know that it was not really essentially a democratic a democratic, let's say, issue. Then we have modern constitutional forms. I analyzed the tribal democracy, internal clauses, and other things that does not allow, forbids changes or even participation of the people in this kind of very concrete topics. I end with a verdict. I sent the Dicasteria, which is my first intention was to open to the reader, potential reader of the book, to decide who is the guilty, who is if it was or not a pejorative understanding of the role of the people. But then someone that read my introduction also was saying me, okay, Antoni, but you need to take part. So decide, what do you think? I say, well, for me it's clear. So decide it, because otherwise it's like, you are cleaning your hands. So I say, okay. So I myself condemn Aristos for the failure of popular route to constitutional experiences. Some of them we can also blame Demos, but that was my. So this is simply a let's say a first picture about how things are going to go. Then I analyzed the concept of crowd, again, from the very ancient experiences to nowadays. I divide the concept of crowd in traditional offline crowds. I didn't find another better word, sorry. And then online crowds. In offline or analogic, I think, because as I said, I don't know. It's what we understand as what is the normal crowd, right? I'm using these different terms that can be associated, some of them synonyms, others less, but demos, kletos, laos, all these are Greek terms. Then I'm also using the concept of civitas, which is a little bit different, because civitas implies citizenship, which is not necessarily the crowd. But I'm playing a little bit with this in order to cover how Roman authors were considering the crowd, right? Again, the Athenian polis. Then jumping to the medieval crowd, concept of crowd from Thomas Aquinas. Then I'm analyzing a little bit more in depth the Arabic and Islamic analyze of the concept of crowds, which is extremely influenced by Aristotle. In Al-Farabi, Ibn Sina, Ibn Pasha, Ibn Khaldun's Al-Sabiyya, Esprit de Corps, which is taught in French, which is understood as a mass and ignorant and virtuous that do not know the jurisprudence of the Sharia. Since one of the heroes of the book, which is Machiavelli. Machiavelli is one of my heroes, I need to say so, because he's the first that clearly do not treat pejoratively the mass, the citizens, especially in the discourses. As you know, Machiavelli wrote the same year, I think it was 1537, The Prince and the Discourses. The Prince was because it was the Pope who asked him to write it, and the Discourses was his own book, where he explains and he's using the Roman experience and the Roman concept of civitas and citizenship. So it's a way of a rehabilitation of the concept of the concept of mass. For the very first time, at least that clearly in my eyes, so it became my hero. And I'm analyzing deeply the Machiavelli of the discourse and the role that he was finally describing, because he was describing what the citizens in Rome how were politically active at the side, etc., etc. And then he was also, of course, exposed for all these northern Italian republics. Then we go to crowding republicanism, Montesquieu, who is also someone who that in l'esprit de loi, who is also, let's say, following this less pejorative and rehabilitating position of the mass that initiated by Machiavelli. I work out with the people and nation. We can discuss later on in the question and answers if you have interest in one of each of these concrete episodes. And then again, the Federalist and then the Federalist, because I think this was after the Glorious Revolution in the United Kingdom, in England, I will say, in England, because then how this all this dialogue between French enlightened and Americans, founding fathers and drafters, how they ended by determine the role of the people in modern constitutionalism since nowadays. So then I jump into a little less legal and political philosophic definition of crowd, because I thought it was very interesting also to analyze what the concept of crowd meant in basically in the 19th century French, not only French, but basically French definition of crowds, which is Les Ligas, Gustave Le Bon. You can see how he thought that they were pathological and irrational. So Gabriel Tarde, public and crowds, so he's making a very interesting difference of what a crowd is and what a public is. And he's analyzing, so he analyzed the crowd psychology, which is, I think, very interesting even nowadays when we are trying to analyze how the crowd behaves in let's say Twitter or with anonymity, without anonymity, etc., etc. And there's Elias Canetti, which is a Russian. I know with this surname I thought he was Italian, but apparently he was Russian. Anthropomorphic genealogy of the crowds. Then this is I think it's a really admirable and amazing work of Giovanni Sartori of the Homo Videns, and how the Homo Videns behave and how we change it. He was the one saying first that there was a kind of natural evolution from the sapiens, Homo sapiens, to the Homo Videns, that all the screens that we have, the TV screens, he was focused on TV basically, because at that time the mobile phones were not that much used. So he was saying that the TV was how it changed the nature of the human being. And then I follow up following a Sartori idea on the Homo Digitalis, and how all this new digitalization, digital process, etc., even this way of teaching in pandemics that was extremely criticized by Giorgio Agamben. I really recommend you to read his page, web page. So how this is affecting, and how do we understand each other as a human beings? How do we communicate, etc., etc. Then I end with this new online crowds, which is basically online again, with Castells, with Van Dijk, and the concept of digitalization, virtual identities, and more behavior in digitalization and in digital arena. New concepts of public sphere, which is I think it's extremely interesting when someone has analyzed, for example, Jürgen Habermas, and how this has been transposed, and how this changes when we're talking about the public sphere in the digital arena. So these are some examples of the crowds in Rome, right? How were the crowds? But all of them are. This was, I think, they were waiting to buy a mobile phone or something. In the right side, of course. And this is how online crowds are. Today we are in a little online crowd, but let's say we are in a kind of online crowd. And as I said, I mean, apparently, if I'm listening myself, and it looks like it's a kind of worried, etc., etc., but it's not the case. I mean, because of this online crowd, I'm able to talk today with you guys, to expose my book, and to be virtually in Pisa, talking with my friends and professors about this book. So this is a tool that we did not have before, and that we can exploit not only to talk about books, but also to implement other aspects of constitutionalism. So the following, after analyzing crowd, as you see, I'm following basically this cognitive, linguistic analysis of Saussure of each of the words. I'm starting with democratic, then with constitution, and then with crowd, and then sourcing. I analyze in the book 3 normative proposals of the net, which are very interesting, and I think we can really learn about. The Lex Informatica proposed by Reidenbach, which is a kind of international law to be applied to make a kind of regulation of Informatica, Lex Informatica, right? Then the code, which is Lawrence Lessig, which is also very interesting. And then Teubner, but it's not only Teubner, but also the ICANN and other German proposals on to regulate a lex digitalis, which is not the same as a lex informatica. It's more concrete. It's more related of limitation of powers of, let's say, the big tech companies, because Teubner is also questioning whether we can define, let's say, Google laws or Facebook laws as a kind of different sort of constitutionalism, right? And who is the one providing or restricting rights of the people expressing themselves? I think that it's not an exaggeration. I think it's a good example because of the transcendence, also in identitarian terms, and the way of how do we express ourselves nowadays through these new tools of technology. Is, if it's increasing as apparently it is, it shows you that we need to have some kind of regulation restricting the power to provide a sort of answer to protect rights of the people, even that they are using this kind of private big tech issues or technology like Facebook, Google, or others, TikTok, I don't know. So, whoops, no, yes. So this is again the evolution of the network society and democratic constitutionalism through the Homo Digitalis that I was working, and Techne Episteme and Technology and Modernity from basically Marcuse. The book that I'm using is I, Robot of Isaac Asimov, because I read it when I was 12, and I was panicking at that time. I'm saying, well, robots are going to rule us, and I was 13, so it was like a long time ago. And down you can see this picture of the evolution of I think it represents perfectly what Giovanni Sartori is saying, and others we are then following up from digitalization, that we cannot simply express in this picture, because nowadays it's so holistic and exponential, the changes that we have, that we cannot place it in a simple picture. Then this is important because the Techne Episteme, I think it then it's related about how, I will explain now in 5 minutes or so, how this affects the understanding of what constitutional constitutionalism is. Because you know, the difference between doxa and episteme, that the opinion and one thing is opinion, and the other thing is to know something, right? So and episteme is something which is scientific. It's not based on opinion. It's not doxa, and this is something that then we can transpose it if we have some techne, and how episteme is affecting the distinction that we're going to use in order to distinguish when the people can be participate or not in some constitutional, not only drafting, but also interpreting. So yes, some examples that I'm working to protecting the Homo Digitalis, because my idea is to protect the Homo Digitalis, the guy that was in front of the screen, but also the ones, all the ideas of Lessig and Teubner, they're also focused on how do we protect us, I mean the new Homo Digitalis, not only in terms of our data management, or how they collect our everything that we're doing, but also examples that people dying in Taiwan after 3 days online gaming, etc., etc. We are seeing that it's happening more than, it's not now only an anecdote. It's happening in a more regular basis. Then all the possibilities in order to change basics like the concept of citizenship. I'm working with Koshenov, provocative book on citizenship, and how digitalization can help in order to improve one of his basic complaints on on citizenship. And then the concept of public sphere. And now I'm going to go very fast to the how I apply all these let's say theories into the constitutional making. First, what I'm doing is to introduce also an evolution, how the people was starting to be as a ratifier, with examples of Napoleonic France, Césarisme démocratique, the abuse of the referendum by Bonaparte, then the goal and other examples of democratic transitions in the 70s in Spain and Portugal, and then in the 80s, Greece, Latin America in the 90s. So the people behaves as ratifier. Yes, they vote, we ratify. Then the following step is the one that I am analyzing here, I believe, which is going a step forward, which is I define as a participatory, more participatory constitutionalism, which is the example of the Colombian constituent process, La Séptima Papeleta, and the concept of constituent nation, which also appears in the Constitution of 1991. La vamos a hacer toda la gente, la Asamblea Constituyente. This is an amazing procedure. I really recommend you to read, because it was a constituent process, a transition to democracy, and at the same time, a way to establish a pacification of the country. So it was all in one. And you can see how the illusions, how the people were putting on all the kind of wishes and expectations in a constituent process that it was more open as the simply ratification process that we had until that time in the 1991. Finally, of course, I'm working with the case of the Icelandic experience and the Chilean one till the mid of 2022. I analyze which are the opportunities that these procedures are opening, like constitutional authorship. I remember Frank Michelman, the real concept of equality in terms of isonomia, isogoria in the ancient sense of the term equality, and also as a way of conflict mediation, because if you are allowing the people to participate, to be the authors of the Constitution, you can also establish a kind of inclusive and mediation aspect, which is one of the goals that the Colombian process had in the 90s. And then on the other hand, I also analyze the risks of these kind of procedures, which is a kind of abuse of constitutional crowdsourcing, for example, based on spurs or status quo or economic elites, as Carlos Bernal was exposing, and which also represents, at the end of the day, in my understanding, the main reason of why the Icelandic experience did not, at the end of the day, succeed in the sense of to become the text of the final text, right? It was in my understanding, a betrayal by the parliament. So, and this is one of the guys that I think we need to talk about when we're talking about constitution and constitutionalism. I'm still thinking why, for example, my good friend Joel Colon Rios, I had this conversation with him and others. They love this guy, but this guy is a Kalish meat of the 1791. I think he was, and I will justify why I'm saying that. And then I'm using this. I don't know if you are aware about this book of Stefan Zweig, Fouché, that he explains who was Fouché. So I think Sayes was even I have even more deep as a political animal in the, let's say, the Machiavellian sense, of the French revolutionary period, from the Jacobins, then the Girondins, and also at the end of the day with Robespierre. And he was one of the three members of the consulate, abusing of the concept of Césarisme politique. He is the one of using and establishing this way in order to have this kind of legitimacy. So all the scholars on I think all the scholars on populism, they will need to take really attention about this concept that Sayes was establishing and using and abusing. He was one of the drafters of the Constitution of 1791, by the way, that did not abolish the monarchy in France. So yes, Dark Bider are my friends, because I think we are in the darkness of the side of constitutionalism. To open, let's say, finally this Pandora box of interpretation. And yes, I'm using this picture of the side of the darkness, because I think we can open this new sort of constitutionalism to amateurism and non-professionals, which some people immediately get panicking. What I'm doing, and with this I will end, is establish two sorts of, let's say, courts. The first one, I'm sorry because it's the other way around. The first one would be a citizen judicial council, which is a committee of universities, representatives of public associations, unions, employers, etc., that they need to decide when a decision, a case, is or not essentially legal or political. And in this case, I also introduced this kind of in dubio pro populo, meaning that if there is a doubt, we need to understand that it's political. And I'm imposing as a rule the judicial restraint. You know, this magic word, judicial restraint. I would like to see in Spain some people saying, no, sorry, but this is not up to us as a constitutional court in Spain. I think the holistic empire of constitutionalism is not helping to our magistrates in constitutional courts to restrain themselves. So, but to arrive into this citizen judicial content, then I install or create this kind of e-dicasteria, because I'm using this electronic way to participate, which it will be a modern constitutional jury. And as I said before, and I'm explaining the book deeply, they need to be adapted to each of the systems, if it's continental or common law, weak or strong control of constitutionalism. Then there are limitations of temporal considerations and state of emergency exceptions. We can, of course, then adapt this idicasteria to concrete periods. And it will be a way that the people is allowed to participate, to vote when a decision of the Constitutional Court is merely political. I'm, of course, using, and I'm not the one saying so, I think it's also acknowledged, probably also in the Italian constitutionalism, but in Spain it's clear that constitutional court and the constitution is a political, also a legal norm, right? So it has this dualist nature, which is also follows this Schmidt and then Bochum for the clearly statement that some elements of the constitution are political, others are legal. So the question at the end of the day is, okay, if there is a constitutional court who is exercising a kind of empire, because as we know, the constitution is the supreme norm, and as I said, or this is of course my opinion, it has a realm, an empire. It's finally the sovereign in the whole pyramid, Chalcedonian pyramid that we have. So the guys that are participating are deciding when they are taking a decision, which is basically more techne, and I'm now jumping back. It's okay because people is not, they have not background in legal norms, right? But if the decision is politically, the question will be why, in the name of what, in which kind of legitimacy a court which is not elected by the people decides on political grounds, when the call it should be directly to the people to decide whether they want a decision to affect or not politically things. Of course, there are all the limits, which are all these dogmatic, let's say, dogmatic sections, and we started the mystification. Here comes again Andrew Barato, mystification of the Constitution, which is all these fundamental rights that cannot be stepped by no political reasons. So I mean, at the end of the day, we will apply also legal norms to protect fundamental rights and the rights of minorities, let's say. But when the decision is politically, it should be a way to allow the people to decide. And the way that I propose is this idicasteria after the filter of the Citizen Judicial Council. I learned experience of the Icelandic case, and I don't wanna threat the existence of constitutional courts. Not in this book, maybe the one that I'm typing now, but the thing is, we cannot, because for different reasons, but also because someone needs to decide when the question is related with more technique and it's legally right. And this is basically what I did in my book. So thank you very much, and I'm eager to listen for your questions and answer and questions and comments. Thank you very much.